Yes, as I say, part 2 of a 3-part series. Yesterday's was great. I got a pile of questions that we're going to deal with at the end. So I'm going to come back to them. But the purpose of today is to work with Suzana Popovic-Montag, the managing partner at Hull Hull, and counsel to the firm, Jordan Atin, to talk a little bit more about estate planning, and especially advanced estate planning techniques is the sort of focus of today's discussion. And as I say, we're going to circle back a little bit to what happened yesterday because of the nature of the questions that I was sent. In the last session, which is going to be Tuesday, right after Thanksgiving, and I always love holidays like Thanksgiving and Christmas and the Jewish holidays and any of the holidays that people have to get together, because it always brings about either good or bad, either contentiousness or people start to think about doing their wills. So either way, it's good for estate planning. So Tuesdays will be again at 1 p.m. Today's started at noon, but we're going to start at 1 on Tuesday. And we're going to talk a little bit about life planning and some of the issues surrounding that, and spend a little more time on powers of attorney and some of the other sort of offshoots of estate planning. Okay, so today, probate avoidance. Suzana, maybe I could just start with you, and maybe you could just give us a little bit of a history. Jordy was kind enough to call it probate fees yesterday. I refused to. I call it probate tax because it is what it is. It's a tax, but it is technically, of course, known as probate fees legislatively. Suzana, can you give us a little overview on that? Because sometimes people don't entirely follow why you'd have more than one will, and maybe a little bit of the history as to how this all came about and why the probate tax is such a hot issue whenever you're considering estate planning.
Of course, Ian, and hello to everyone. Probate avoidance, or probate tax, as some people will try to refer to it as, is a wonderful thing for us as litigators, because it really gives people something to fight about when things don't go right. Now, the whole probate process is a legal process where someone submits a document to the court and seeks affirmation from the court that it's the last valid will of that individual, and appoints an executor or an estate trustee. And not every will has to be probated. Now, for the most part, we find that many wills do, just because of the fact that the banks typically will require a will to be probated. And if you want to sell real estate, for the most part, many times you'll need probate as well. But you don't have to probate every single will. And many times people will enter into a process where they're planning for the avoidance of having to apply for probate, because when you do apply for probate, you've got to pay this tax. And it's actually an estate administration tax, which amounts to about 1.5% of the value of your estate. So if you're looking at a $500,000 estate, for instance, that's a tax of $7,500. For a typical estate in Toronto, which has a house, $1 million estate, we're looking at $15,000. Now, I know that's not an insignificant amount, and not for any of us, but when you compare what can come out of estate litigation and the fees that can be generated as a result of things going wrong because people have been doing all these wonderful machinations to avoid this tax, it's shocking how many more times than that amount you spend on legal fees trying to correct a wrong. So there definitely is a process that's a good process in terms of, making sure that things can be done, and that the executor is given the authority to deal with things, and that everyone recognizes that executor as having the authority, but it's not always required. So we just want to keep that in mind when we're doing our planning. So Ian, we've got you on mute.
Ian, you're on mute.
Can you believe I did that?
I know. I'm loving it. I'm loving it.
I just can't believe it's a bad day. Of course, we, from a standard of care and negligence issues and all of that swirling around when we're preparing wills, one of the things that we do want to consider is how we can avoid that probate tax, so someone doesn't come back to us and say, we could have avoided it. And and I guess the history of this, just a little bit of history on this, is the Gronowski decision back in the late 90s, where Justice Greer said that you can have more than one will and isolate assets to those specific wills, and therefore in a way, avoid probate tax on some of your assets and not on others. That being said, Jordy, your example yesterday came up pretty stark. Now that was a fairly high net worth illustration with Claire Dunphy, but came up pretty starkly that the savings of probate tax can be significant. That it was in the hundreds of thousands, or I think, I forget the exact number.
No.
But even if you're going to save your client, if you're going to get your will done and there's a way to avoid some probate tax that saves you $2,000 or $3,000, it can pay for the whole trip to the lawyer. And so it's like accountants. They always used to be able to say, look how much tax I saved you, so you should never ask about our bill. Well, lawyers now have the benefit of being able to say, look at how much I saved you. And that's important, because that's another reason to just get to the focus of doing a will. You're not going to save money instantly. It's a savings in the future, but it's one that can be, the will process itself can pay for itself. Okay, so Jordy, you're just calling up your screen and
well, just to your point, unless you're using software that can help you as a lawyer, the lawyer might not be able to put into specific numbers sort of what potential savings there are. And so, as Suzana said, you basically just say, 1.5%. There are a few machinations and things like that, but it's helpful if the lawyer could show you when you're setting down, you're coming to the point where you're planning out your will. And, in this case, as Ian, you've said, you're looking, at $117,000 of probate tax, which can be avoided, or at least partially, by using a secondary will, because in this case, your lawyer would be aware that, for example, that because you own shares in a private company, considering to use multiple wills is a good idea to avoid that. And the lawyer can demonstrate to you as the client, and you should ask this if you're the client, how much can I save potentially? And of course, these are just snapshots, and the numbers change around. But just by using multiple wills, you can see that you're saving $45,000 or close to it. And so that's something that your lawyer should be talking to you about and illustrating, and can be done pretty easily using software. And then it becomes your decision as the client to say, yeah, I do want to take this extra step and potentially save this money when I pass away, or no, I don't. But at least then it's a decision, and that's been made with eyes wide open and with an illustration of sort of what's at stake. You're on mute.
I know, I was just about to walk over to do that. Got caught twice now. Okay, so yeah, exactly. Okay, so that's the sort of overview on why you have multiple wills and why probate tax is something that can be an important planning step. Let's talk, Suzana, maybe just about the kinds of illustrations, and we talked about one yesterday, but what techniques exist, and then we'll talk about sort of the mechanics. What techniques exist to help avoid probate when it's not by way of a secondary will? What other tools exist?
Well, Jordy talked about the concept of joint ownership yesterday, and that's one of the easiest illustrations of how you can own property or assets without having to, on your death, have them fall into your estate, because they're going to pass outside of your estate to the surviving joint owner. Another mechanism and way to plan is to use beneficiary designations. So if you have RIFs or you have RRSPs or pension plans or certain financial accounts, it is possible that you can designate a beneficiary or beneficiaries who will be entitled to those funds after your death. And again, those assets won't fall into your estate and won't have to be included for the purposes of any probate tax calculation. And we've talked also about multiple wills, of course. And then finally, there's this concept of using just a bare trustee and having someone be a bare trustee of a trust to hold assets in their name legally for the benefit of the ultimate beneficiary. And the idea there is that the trusting, and that is to transfer the property to the beneficiary when called upon. So by having assets in the name of a trustee in a bare trust kind of situation, it's yet another mechanism by which you can avoid having those assets flow through your estate once you actually pass away.
Okay, so Jordy, you've got up on your screen. Let's talk about some of the mechanics of these tools, these probate avoidance tools.
So as I described yesterday, you know, joint ownership is a mini will for that asset. And that's fine if you want that, that asset to go to that other owner with no strings, right? And that's the easiest way to do it. And it's actually the best planning technique because it avoids that probate tax, as I've illustrated. But the other option that Suzana's raised is the idea where you don't really want the other owner to get the asset. You just want it to pass to them for ease of administration and to avoid probate tax. And so, for example, if, you know, in the scenario where the spouse wasn't alive, Claire said, look, I'm going to make Haley the joint owner of my home. And you hear this all the time. The idea is that the home is going to pass to Haley, except that Haley is not, it's not going to be hers. The intention is not that it's hers. It's more that she just gets title to it and then distributes it in accordance with the rest of Claire's will. And so you can almost have your cake, that is avoid probate tax, and eat it too, and have it go to the beneficiaries that you want. And so that's a technique. And basically the way, what we describe that relationship is that Haley, even though she's the joint owner, is really holding it in trust for the estate. And so she's a bare trustee, is the technical term. And so she's required by law under that arrangement to deal with that home consistent with the will and however the estate is to be distributed. So that's the idea. The key element of that, and where many advisors can go wrong, is that they think that that by itself is going to avoid probate tax, when in fact, you need a separate will as well to deal with that, a secondary will to deal with assets that pass outside the estate but are really owned beneficially by the deceased. And I don't want to get too high level or too into the details here, but unless, Ian, you want me to, but that it requires, if you're going to look at probate planning, it requires some expertise. It's not a simple, just put everything joint, especially when it's not a spouse, and avoid it, because that's the advice that many of our clients get, and it's wrong. It doesn't do what we want it to do.
Absolutely, yeah. So I think it's just a nice, you covered it well, and it's a high level. It's something to watch out for. Okay, so in terms of the tools, we talked yesterday a little bit about designations, but Jordy, in terms of that, when you're getting your instructions for designated assets, I see you've got a life insurance policy there, or whatever tool you want to do. What are you typically going to ask the client, and how are you going to manage that issue?
So when you go to meet with your lawyer, they're going to want to know about your assets. And one of the key reasons they want to know about assets is to identify assets like life insurance, like RSPs, like TFSAs. And there's a limited number of those kinds of assets where you can designate the beneficiary right on that asset. And so it's again, like a mini will for that asset. And so that's one of the reasons why full disclosure, bless you, Ian, full disclosure and getting all that information to your lawyer is so important. Because here we have a situation with life insurance or an RSP or other assets. You can designate the beneficiary right on, and by doing that, you can save the probate tax. The big problem, and this is where the lawyers have to advise you properly. It's not as simple as just designating, oh, I'm just going to designate one kid as the beneficiary of my RSP, and that'll save probate tax, and I'll give the other equivalent money to my other kid in the form of a GIC or something like that, because each asset has its own tax implications. And one of the things that your lawyer should warn you about is that the tax on an RSP, which is huge, can be 50%, is actually not paid by the beneficiary, but paid by the estate. And so if you've set up this routine where you give the RSP to one beneficiary and the residue of the estate or the balance of your estate to another, what you've done there is said that the beneficiary of the RSP gets the full value of the RSP, but that the tax is actually paid by the other people. And that's a warning that your lawyer should give you about that and that planning. And so it's not as easy as just doing it yourself. It's got to be looked at carefully, because there are tax implications on RSPs.
That's great, Jordy. Thank you. Suzana, did you have anything else you wanted to add to the probate avoidance generally before we move on to the next topic?
Yeah, I think I'd like to just remind people that when we're dealing with beneficiary designations and they're being made specifically on the instrument themselves, as Jordy said, and become sort of a mini will on their own, there are also lots of situations where we see people address these designations in their will. And when they do that, it's important that, you know, it's being done properly. So if they're changing, for instance, a designation that was on, you know, an RRSP with the bank, and they want to change it in their will, they've got to make sure that they're following the legislation and doing so properly, so that they're referring to the policy specifically and carefully, and that it becomes clear that that is the intended change in that designation. And that becomes important because a will speaks from death. So when you pass away and you refer to any designations in your will, it's only going to refer to the policies that you had owned at the time you made your will. And so if there are subsequently acquired assets, or not assets, but designations that are made, they have to be kept in mind. And if you're going to change those subsequently, either without you know, dealing with the institution itself, but by virtue of your will, you're going to want to consider updating your will or preparing a codicil, just so you're making sure that you're keeping up to date and, you know, addressing all of the possible designations that you have out there. And that becomes particularly important when, you know, you see people separate or divorce, and they forget that they've made these designations previously. And, you know, at the end of the day, they pass away, and suddenly an ex-partner is entitled to something that they never would have otherwise wanted had they not, you know, given some thought to it and readdressed their estate planning after that designation was made.
That's such a good point, Suzanne, at the end as well. But the one at the end, and it reminds me that often the homework I have my clients do before, if they can, but maybe after, if they haven't got it ready, is go talk to their advisor and find out what they did. Excuse me, sorry. Find out what they did, because sometimes you're not sure what you've done. You might have bought a policy years ago and you don't really even remember what you did, or your group policy at the office. What have I done there for my life insurance? So that's such a good point and an important piece of homework. Jordy, did you have something else you need to add before we moved into the next part?
No, that's great.
Okay, so we've got the family tree up, which is a great transition into the next area, and that we're going to just talk about foreign issues, foreign assets, U.S. assets. Many of our clients will have even modest homes in Florida or something like that. Will come and see us, or they've got inheritance property in Europe, or those kinds of situations. But Suzana, can you just give us an overview of U.S. and foreign issues generally to consider what you should be doing on the will planning standpoint?
Sure, Ian. Whenever I have clients talk to me about foreign assets, I think the thing that comes as most likely to come out of my mouth in terms of advice is to consider going back to the jurisdiction where the foreign assets are actually held and retaining local counsel there to actually prepare a will that's going to be in accordance with the jurisdiction's requirements and is basically foolproof from the perspective of making sure that it's going to ultimately be properly executed, properly enforceable, so that it's the least complicated way to do it. I know people are very hesitant to make one will, let alone another will in another jurisdiction. But from what I've seen on the litigation perspective, it's just almost always better to have done so. Now, I realize that's not required and that there are planning mechanisms, certainly, and I expect Jordy's going to be addressing them, that can be incorporated in Ontario wills for foreign assets. But my general rule of thumb is just to suggest to people that they actually get someone in that jurisdiction to, if not to create the will at first instance, then to review the Ontario will to see if there's anything that might need to be done to make it a little bit more certain that it's going to work at the end of the day.
All right, thanks so much, Suzana. Jordy, let's talk about U.S. and foreign issues. We know Suzana's advice is excellent. What are some of the steps that you take when you get in a situation like, and obviously the Claire Dunphy one you've got a multicultural, multifaceted family arrangement here, people living all over the world, so to speak, or come from different parts of the world. They may have assets in different parts of the world. So what are your thoughts?
Yeah, so one of the things that your lawyer is going to want to know is about citizenship, because let's say because different jurisdictions tax differently, have different rules depending not only on where you live, but what kind of citizen you are. So for example, the United States, if you're a US citizen, regardless of if you live there, regardless of if you've ever even been there, if you're a US citizen, they do claim the right to tax you under certain circumstances. So one of the questions that your lawyer is going to want to know is anybody out there a US citizen? Because that's going to take into account or take into consideration other factors. And then where do people live? So, you know, that's gonna matter in a whole bunch of different issues. So one of the issues, you see here, we've made Phil a foreign resident. So, you know, there's a whole bunch of issues there because if they're a foreign resident, foreign citizen, there may be tax implications to them being a beneficiary. If they're acting as the estate trustee or the estate representative, it could raise a whole bunch of issues for them when they came to take over the estate about administrative difficulties, foreign reporting, and things like that. So that's why those kinds of issues are going to be raised by your lawyer when talking about that. And so, yeah, the beneficiary themselves, really important for them to, and for you to disclose that to your lawyer. If they don't ask, they should, but if they don't, because there may be implications. They may not be able to give you advice. So if somebody's a foreign citizen, for example, who's a beneficiary, I won't be giving advice as to what the impact will be, but I will be saying, look, that might be an issue, and you probably should get some foreign advice, or at least understand that I'm not giving you foreign advice on those issues. So your lawyer may restrict that as well, because and get you to either sign a foreign advice waiver, which means that I'm not giving foreign advice, or just confirm that. So that's how citizenship and foreign elements for a beneficiary is relevant. So
Jordy, let's just pick up on that point about executorship, because I think that's a really important. Often, your foreign jurisdiction connections might have an impact on that. Can you just talk a little bit about that?
So if you're thinking about appointing an estate trustee who's, most relevant, lives outside of Canada, I mean, even Ontario, but outside of Canada is an issue, because there are a bunch of different hurdles to jump. One is that a foreign person, including a person in the US, has to, before they become the administrator of an estate, has to post security or an insurance policy, in essence, that they don't run off with the money. So that's a hurdle they have to jump through. Secondly, if they're resident in the United States, for some purposes, they may have to come up to Canada and be here, physically present to deal with certain things. US like a person who's an executor of an Ontario estate who lives in the US would have foreign reporting obligations in the US. So there's a whole bunch of documents that they'd have to deal with that. There are also potentially tax issues, rendering that estate or that trust a foreign trust, a non-resident trust, which has tax implications. So there's really a whole bunch of reasons why, in a perfect world, you would not appoint a foreign resident to be an executor or a trustee or an attorney for property under a power of attorney. I know we'll talk about that in the third section, but those are all things that's why a lawyer is going to be wanting to know about that. But if you can remember, hopefully your lawyer, again, will have a checklist like this.
Okay, so thanks so much, Jordy. And we're going to try to, I know you have to leave a bit early today, so I want to get through the last two topics before you leave, and then we're going to deal with some questions. So unless, Suzana, you have anything else to add on the foreign assets issues, I'd like to go to the next section. Is that okay?
Yeah, for sure.
Okay, so Suzana, the whole question of blended families always often comes up with estate planning. It has implications on life insurance, spousal trusts, trusts generally, domestic contracts, and the like. You mentioned earlier, though, you were mentioning earlier about common law spouses as well and their rights. One of the questions that I'm just give you a heads up after Jordy leaves, we're going to talk about are specifically common law spouses and common law rights. But can you just give us some overview comments on planning with blended families and the nature of your retainer in the context of a blended family, if you wouldn't mind?
Sure. Blended families are quite common in my experience, and I'm sure others as well. When I was just looking at some of the statistics recently, I couldn't find much more recent than a 2012 statistic from our census that said that about 12.6% of the families in Canada are blended. And that was in 2012, so I would venture to say that that number is even higher. So we've got more than 13% of the people in these situations. And so we're talking about, you know, two sets of children, perhaps even more sets of children, and different individuals who have to be provided for or want to be provided for by virtue of an estate plan. And so when we're looking at the pot, and it's only so big when it comes for the purposes of distribution, we look to see what other kinds of mechanisms we can look at to perhaps deal with this funding mechanism, which could become a problem when we have a situation where there is, let's say, a second marriage situation, husband and wife. The husband wants to provide, of course, for everything on his death to the wife and make sure that she's taken care of. But once she's passed away, he'd like his children to get what's remaining. And so when we're in that kind of a blended situation, we're looking at means by which we can plan for both sets of the family so that there is enough to be shared and that everyone feels, you know, somewhat entitled and taken care of at the end of the process. And so things like, you know, buying life insurance to provide for some beneficiaries at the end of the day, and using the rest of the actual estate itself to provide for the family is one way to do it. The spousal trust we'll talk about, I'm sure, in more detail too, where you provide for your spouse during their lifetime, and then on their death, we're going to share what's left either amongst our own children or all the children of both blended families. Domestic contracts become a really big consideration when we're talking about planning for these situations, because, you know, there's certainly the cohab agreement initially, and then possibly a marriage contract once that's been formalized, if it does get formalized. And, you know, there's also this concept of mutual wills, this agreement between two parties to not change their will and to provide for each other during their lifetime, on their passing to provide for the surviving spouse, and then on the passing of the surviving spouse to provide for all the children. And so those are the typical ways that we see that people are planning for these situations, and then it just becomes a matter of which one works best for your particular situation.
Thanks, Jordy. Can you give us an idea, first of all, how you manage these sort of circumstances and the excuse me, I'm having a terrible day with my allergies. Retainer issues.
Well, yeah, I mean, I think Suzana's suggestion about insurance is the best way to deal with a blended family situation, or one of the best ways. I always say that before you get into a second relationship, buy as much life insurance as you can, because if you have kids from a prior relationship, that's a great way to provide for both sets of beneficiaries, your new spouse and your children from a prior relationship. So, you know, it's your lawyer, if you're in a blended family situation, some lawyers like me, for example, won't act for both spouses if either of them has kids from a prior relationship. So you may come across a lawyer who's reluctant to do that. There's a good reason to do that, because, you know, so many claims come out of blended families. I think I joked last yesterday about how, you know, our business, my job is partially just like Cinderella, Disney film. And, you know, we're providing for the evil, you know, the quote, evil stepmother, and the children and Cinderella. So Cinderella's father was in that situation. Should he give the home to the evil stepmother, or give it to Cinderella, or set it in a trust, or what? And we know that didn't work out so well in Cinderella's case. So that was an example of some bad planning, I think. But that's really the reason, because the lawyer wants to be able to give independent advice to Cinderella's father about the home, for example. So if you imagine that Cinderella's father and the evil stepmother sitting together with the lawyer, and this evil stepmother saying, honey, give me the house, give me the house. And Cinderella's father says, okay, give the house to my new wife. You can see how that could raise concerns that there was undue influence, or that Cinderella's father didn't really have the chance to say what he really meant. Did he really mean for his stepdaughters to get the home? So, you know, those kinds of elements, that's why you might find that the lawyer is reluctant to act for both, because of that. Some lawyers do act for both regardless, but it does give rise to a lot of questions. And what you really want to make sure is that you have the ability to be free and open about how you feel about your kids versus your stepchildren and your spouse, and having a separate lawyer for each allows that.
So, Jordy, you've just got on the screen the surviving spouse scenarios. Maybe you could just talk through that, and then Suzana, you could have some of your, maybe some practical experience in these various scenarios.
So I'm a big believer in visualization, as you can see from the software, and limiting sort of the number of options that you have to consider. So I've broken this down into sort of 3 options for a client. So if you're sitting there thinking about what should I do if my spouse is alive when I die? Option 1 is you give everything to your spouse, no strings attached, and hope that they do what you would want them to do. But there are no strings. They could do whatever they want, including cutting out the children or giving it to a new spouse or whatever. The other option is, as Suzana explained, using insurance, for example, to give some amount to the children immediately, even if your spouse is alive, and then giving the balance of the estate to the spouse. So that's sort of where you're giving, as we talked about, absolute gifts to both groups. And the middle one is this idea of a trust. And it's as I described it yesterday, it's using the word but. If you use the word but, then you want to trust. So here's how the description would go. I want my spouse to be able to be supported during their lifetime, but when they die, I want to make sure it goes back to my kids. Well, that is a but. That means a trust. And this is an example of how a trust would work for a surviving spouse. And I don't know, Ian, if you want me to take you through that, or
I do.
Okay.
Please, if you don't mind, just take a couple minutes. I know you've got to run, so maybe that's.
Yeah, no problem. I'm good for time. I just didn't. So this is how basically a trust works for anybody, in a sense. So you would say, okay, I want to give my spouse $1 million to live on. So that's the principle. And I'm going to put a person in charge of that money called the trustee, who's going to invest that money. And whatever's left over when the spouse dies is going to go to my kids. So the spouse can't change that. The surviving spouse can't give that money to someone else. It automatically, whatever's left over when the second spouse dies, goes to the kids. So you can see how that can protect the children. It means that if this spouse gets remarried, they can't give this principle to their new spouse, right? That's the protection. Of course, with every decision, there are a whole bunch of issues. There are certain rules for a spouse that so if you took $1 million and the trustee invested it and it generated income like dividends or interest, that would go to the spouse with no strings. So they would get that. But then you can make all kinds of rules about how does other money flow out to the spouse. Is it going to be left to the trustee to decide? Are we going to build in, I want my spouse to get a minimum of 50 grand a year automatically without having to ask for it? Is it only going to be if she or he needs medical care and wants to use that money for that purpose? Is it only unless they remarry. So you can take out as much as you want until you get remarried or cohabit. Now that stops. So it preserves the principle. So anything you can think of, you can add as a rule, what I call, these are the rules for withdrawals. And that's how you build a trust. And that's how you can protect the children and provide for the spouse. It does require picking someone else, a trustee. And we could talk, I think you've talked about it. It could be the spouse, but there's not as much protection. But picking someone to run that whole trust and make those decisions.
And you can certainly see from everything that Jordy's just said, how important it is to pick the right person as a trustee. Because if the goal really is to preserve what's there at the end for the children, then we're going to want a trustee who's got some rules that he or she has to abide by, but also keeps in mind that, you know, there is a gift over beneficiary in a sense who's got to be, you know, taken care of as well. And so those rules or those requirements that we put on the trustee are quite important in terms of ensuring that there is ultimately something that's left over. And that if there isn't, then the children, of course, are going to have a complaint against the trustee and litigation will no doubt arise.
Okay, that's great. And that's a big help because the idea of trusts always seems a bit daunting. But in fact, in a lot of situations, in blended families in particular, it is the most cost-efficient tool to ensure that the wealth passes to the children eventually, but at the same time, the surviving spouse enjoys life as they see fit. And as you've described it, they can have income and they can also take some of the capital or the principal as needed as they go along, all governed by a trustee. So thanks to both of you. That's a great summary of what can be a difficult concept until you so well explain it. Okay, so just I want to save some time for our questions. So let's just move on, unless there's anything else you guys want to talk about on the blended family scenario before I transfer over. Okay. Planning for special assets, such as cottages, corporate shares, pets, loans, and then I know digital assets is something, Suzana, you've written on and have a lot of experience with as well. Maybe you could just give us some comments on that aspect of estate planning and this advanced estate planning discussion. And then Jordy, we can work with some illustrations.
Sure, the digital assets is a relatively recent thing that we've added to our estate planning checklist because of the fact that we're recognizing that certainly people are having much more of a digital footprint than they ever had before. And many, many people have computers. Many, many people use internet banking, for instance, or Facebook or social media accounts. They have iTunes accounts. They have, you know, photo saving places on their computers and all of these assets. And of course, then there's the financial ones, things like Bitcoin and that, where they're either going to have some huge sentimental value or some huge, possibly, financial value to an estate. And we want to make sure that when we're looking through all of the assets and collecting information from our clients, that we are addressing those kinds of assets and what the clients ultimately would like done with those as well. Because otherwise, they're going to be left with possibly no one having access to them, because so many of them require usernames and passwords. And if they fall through the cracks and that kind of thought isn't given to it in advance, then we're going to be in a situation where possibly, you know, no one's going to be able to access the easiest illustration, of course, the photos on someone's laptop or something like that that are saved away. And those kinds of things can be very difficult because the executors don't automatically have right to use people's usernames and passwords just by virtue of their appointment in a will. And so it's an extra layer of planning that we need to build into our process.
Jordy, can you just give us some of your thoughts on these special assets before, and I know we've got probably 3 minutes before you have to jump off, and the timing is going to go well because we've got to talk through some of the questions.
Well, maybe I'll just talk about specific, as you say, specific assets. So when you look at a will as a client, you sort of break it down between initial gifts, which are gifts of specific assets or specific amounts of money, and the balance of the estate, the residue, everything else that gets that flows through. So let's just talk about how you might plan for the family cottage. So you might want to say that, well, I want my kids to be able to live in the family cottage for a period of time, because cottages cause all kinds of problems. Because, you know, you've got multiple people all wanting to live there. That often doesn't work well. So what people sometimes do is say, okay, I'm going to give you a period of time, kids, to live there while after I'm gone. But you're going to have to come up with some rules about how that's going to go. And so what people often do is say, look, you know, you can live in the cottage for as long as you all agree, or, you know, for a period of time, for, you know, for a year or 2 years or 10 years. And the other things to consider are who are going to pay the expenses. So is the estate going to pay those expenses? And if so, what percentage, or the beneficiary is going to pay? How those, where is it going to get funded from? Is it going to get funded from a separate fund that's set aside for the maintenance of the cottage? How long is that going to run? Things like, you know, are you going to be able to buy another property? So if everyone agrees, can we sell this cottage and buy another one and hold that in trust? And the last way to deal with especially cottages is this idea that maybe one of them wants the cottage, but the other ones don't. In which case, how do they keep the cottage but pay out their siblings, for example? And that's typically done with an option to purchase, where you get, you know, valuations, and you can build that out. And that should be discussed with the lawyer. The lawyer should talk to you about those options for remedying what can be a really difficult problem. But if you take your time and you go through the many different aspects of a cottage trust, then what you've done is given your family the ability to hold on to this asset for a period of time and work it out among themselves. And if they can't work it out among themselves, then a fallback dispute resolution mechanism, because as Ian and Suzana can speak to, cottages give rise to all kinds of fights.
Sorry, I just had a little video problem, but I've got my audio is working. Thanks so much, Jordy. Suzana, did you have anything to add on the cottage piece? And then we'll let Jordy dash off because he's got to run.
No, I think Jordy covered it. So great.
Okay,
thanks.
great.
Well,
thanks, Jordy.
So sorry, I have to run.
No problem. Okay, Suzana, could we just spend a few minutes on just some questions? I want to, before we wind up, and I'm just moving around to see if I can get a better audio here. I mean, visual. My audio seems to be working. Can you talk a little bit about common law spouses and what their rights are? You mentioned it yesterday. Over half of, I saw a stat recently, over half of the province of Quebec adults that are in relationships are in common law relationships. It's a common planning scenario. And what can a common law spouse, what should they be expecting or not expecting, or what surprises could be there? If you wouldn't mind spending a couple minutes asking, I've got a question in that regard.
Of course. I think it's really important when we're talking about the importance of wills to really consider it and to realize how important it is when you're in a common law situation. Because without marriage, there are going to be some serious, significant, financial consequences to that kind of a relationship. So if you're in a common law relationship and you die and you don't have a will, then there is no guarantee that your common law spouse is going to be entitled to any part of your estate. So not automatically, they're going to actually have to take steps to make claims against the estate to be entitled to something. And that's one of the easiest reasons why, people should prepare wills if they want to take care of a common law spouse. If you die without a will and you're in an intestate situation, then your family is going to be, depending on the way that it's comprised, is going to be entitled to it. So if you die without a will and you're married, your spouse will get the first $200,000 of an estate. And then depending on whether you have one or more children, either 1/2 or 1/3 of what's left. So it provides for your married spouse and your children if you die without a will. It does not provide for a common law spouse. And so in that situation, a common law spouse is going to have to consider some kind of a claim against the estate. And the easiest one, of course, is a claim for support under our Succession Law Reform Act, which says that, if you're a dependent of a deceased person who doesn't make what the test is adequate provision for the proper support of a beneficiary, then that individual can make a claim for support. And in many cases, we've seen a successful claim against the estate. But it does mean that a common law spouse who's grieving the loss of their partner is now put in a position where they have to fight with the estate representative, who ultimately becomes the estate trustee. And, you know, it's not the best kind of planning, as you can imagine, in the most tragic of circumstances.
Absolutely. And you don't want to be having your common law spouse scrambling after you die for financial certainty. Suzanne, another question that came up yesterday, you and Jordy talked about joint assets. Can you just spend a couple of minutes describing joint assets and how they work? Because one of the classic scenarios still is a joint asset with an investment portfolio or a joint account, but you might have more than one child, but only one child is on the joint asset. Can you just talk through that issue a little bit and help this better understand them?
Sure. That's one of the common situations we see that arise and turn into litigation, actually, is when you have an adult child who's holding a bank account, let's say, for instance, in jointly with a parent. And on the passing of that parent, then the child is going to assert that they're entitled to the whole account by right of survivorship, and that it passes outside the estate and it's theirs. Now you can imagine if there are other siblings who are not named on that account and not going to be so much in the chips as that individual is, then they're going to be quite upset about that and will have to, you know, if they're going to challenge it, they're going to challenge it on the basis that there's this presumption at law that when a parent holds an account jointly with an adult child, that the intention is when they pass away, that it actually results back to the estate. So that there's a reversion back to the estate, and then once that happens, that it gets distributed in accordance with the terms of the will, if there is a will. And if there is a contentious situation, so if the other children are going to take a run at this, then there's going to be a requirement that the beneficiary, the joint account holder, the surviving account holder, is going to have to demonstrate that there was an intention to gift. And that means coming up with evidence that's sufficiently going to convince everyone that yes, this was intended to be a gift and not a reversion back to the estate. And that's an evidential issue. And it's going to be not necessarily an easy one to overcome, but certainly that's something that as we're doing our estate planning, we're talking with clients about, so that if we do need any corroborating evidence of this intention to gift, that we're putting that into place at the same time as these accounts are being established or afterwards, just to make sure that we're protecting the ultimate intended beneficiary of those kinds of assets.
Oh, that's fantastic. Thanks for simplifying both those concepts in terms of the questions. The final question I want to raise, just only because it just came out yesterday, is there's been a lot of advances in the estates area recently. This Attorney General seems to be very proactive in a good way, and they've provided for ability for us now to have remote signings. So we can do a signing of the will over Zoom, which is something we can all consider in this times of a pandemic. And then the other aspect that came out yesterday is that he's creating an online process for probate applications to try to streamline and to bring more efficiency to the probate application process, which I thought was a phenomenal advance. In terms of making it easier for us to do this. We've heard a lot about why we should do it. We've heard a lot about what we should do. This is actually what I say, these are motivators from my standpoint to get you off the couch and do it. So Suzanne, I don't know if you had any other comments in that regard, but I was just thought that was important to highlight to everyone so that we know that the ease of this process, now that you know what you're getting yourself into and what you're going to be doing with your lawyer, the actual mechanics of it have made a bit easier too.
Yeah, and we're all very thankful for that. As soon as that announcement came out, I reached out to our estates clerk, and she was over the moon with the fact that, you know, there is an ability now to file some of these documents online and to try to speed up the process, because we're, as many of you know, here in Toronto waiting up to 8 weeks and perhaps longer, much longer, not 8 weeks, sorry, 8 months to get probate. And so anything we can do to speed up that process is quite welcome. And we're very fortunate that we do have an Attorney General who is as interested in our area of law as we are, it seems.
No, it's great. And it helps us to think about how we're going to plan too, because who knows, and when you're going to die, we don't know, but also what the world is going to be like in terms of its ability to administer things like a requirement for probate and so on. So nice to see some advances in that regard. All right, well, look, we're going to try to wrap up a little bit early today because I'm actually in court in a couple minutes. So hey, Victoria, how are you?
Hello, I'm well. I have tons of questions. If you have 2 minutes.
We sure always have 2 minutes for Victoria.
So I was going to ask, so in the Cinderella scenario, dad and stepmom had a prenup. Kid feels really confident. I know it provided for me. What if the dad's will doesn't go in accordance with the prenup?
Well, they're bound by the prenup.
Okay.
That's the problem for the dad. And, you know, it's sort of like I always say it's akin to having a car lease. Just because you die halfway through the car lease, you can't walk away from the contract. So if you've entered into a contract, again, it comes back to what Suzana, I think, mentioned yesterday. You can't give away what you don't have.
On that topic, I was going to ask, do you want to warn anybody about the follies of like mutual wills? People thinking that because dad and stepmom wrote this will on these terms, again, I don't have to worry about anything in the future.
Oh, that's so true, Victoria. And, you know, it is such a dangerous step to think that just because you've written these two wills and they are, you know, mutual wills, of course, are a curse and at LawPro a nightmare, but really only were around in the late 60s and the early 70s and kind of vanished a little bit. You don't see a lot of them where two people sign the same document. But this idea that people go in and they say, well, look, I'm doing mirror wills, all to each other and then to our kids when they're in the first relationship. But when you get into a blended relationship, that doesn't work. But people think it's working, right? They think, well, we've just done it this way. And then it's all to my wife. And then the wife lives 10 more years, gets married twice, and all the money's gone. That's okay, maybe, but gets married or gets into a new relationship and all the money goes to the second family or all those sort of machinations that come on. And they think when they've done their mutual wills at the time that they've accomplished some sort of contract, and that's simply not enough. And the courts, on rare occasion, there's a Hull estate, there's one down Coburg area that allowed it, but it's so rare that a court is going to say that if two people come in and do separate wills, that they have entered into any contract not to change that will. It needs that one extra step of an agreement or a domestic contract is really the best way to do it.
Absolutely.
I was also going to ask, right now with cottages, thanks COVID, we're suddenly seeing their values rocket through the roof. Are you having people come in and saying, I'm really worried about capital gains when I die? Is there something that we can do to plan for this other than insurance?
Yeah, you know, I have actually seen 2 or 3 just in the last month just on that point because they finished the season and now they're thinking, okay, now we've got to capitalize on this market. And you're right. I mean, insurance is the only easy tool, and the spousal trust, of course, is another tool, some way to roll it over to your spouse. But this government, and I think in future governments, are never going to make it easy. It's going to be, you know, we're going to be in a cash grab for taxes for the rest of our living days. So I don't think it's going to get any easier. And right now, those are the only tools.
Okay, my last question. Do you want to have any rule of thumb on how often people should think about updating or at least reviewing their estate plan?
Yeah, my rule is 5 years. I think it's a safe rule. I don't think it's a good idea to do it much longer than that in terms of looking at your estate plan, not just your own personal circumstances, but things have changed and things will change. And we saw it, and you and I are both of this vintage where we saw the mutual wills, the primary secondary wills come in, and it took literally years for people to catch up on that, even though we were out there telling people this great planning tool. It probably, I remember, like, even coming 7 or 8, it came in the late 90s. I mean, there was probably 10 years before some people with wealth that they could have avoided a big tax were actually coming back to saying, oh, geez, I got to update it. And it's usually because, I know, they got a new grandchild and you're like, no, that actually is still covered. But boy, do you need help. So I use a 5-year rule.
Okay,
so thanks so much, Victoria. Thanks so much for jumping in with the questions too. We really appreciate it. These are fun. All right. Well, on that note, we've got our last seminar on Tuesday, October 13th at 1 p.m., where we're going to talk about life planning and some of the issues that we touched on in a little more depth. So thanks, everyone. Suzana, thank you very much. Have a lovely Thanksgiving weekend.
Thank you,
and we thanks to Jordy in his absence, and Thanksgiving and holiday weekend. Everyone enjoy this weekend too as well. So thanks so much.
Take care. Bye-bye now.
Bye-bye.